Mr. Schaefer appears on behalf of Mr. Webley. Mr. Schaefer, good morning.
Morning, Your Honor.
So I have read the motion. Ms. Williams, did you get a copy of that, Mr. Schaefer?
Yes.
And I've read your response as well. And did you get a copy of that, Ms. Williams?
Yes.
All right. I read it both. I understand it. Anything you want to add today, Ms. Williams, that I don't already know by your motion? And then we'll hear from Mr. Schaefer.
Yes, I'm really just asking to split the summer, no change in really the holidays or anything. And he can also have spring break if needed be. Also, I want to put out that he hasn't been following the school year that he's supposed to come every other month. He only came one time, which was last year, September 2024, and he did not follow the whole thing, which is staying for the whole weekend. He took him to a basketball game with a whole bunch of his friends and brought him back that same day. Other than that, he hasn't followed the school year parenting order.
Okay, so what do you suggest I do about that?
I just want.
Hang on a second. Let me get the question out first. Are you asking then that I eliminate his parenting time during that time frame, or what are you asking this court to do when Mr. Webley has not abided by the parenting time order relative to in-school parenting time?
He should be held accountable because he, like, for instance, before we had a motion to ask to split the summer, that was already asked, he disagreed. He goes so hard about having his summertime with him, which I don't have any summertime with him, or I don't have freelance throughout the school year because I'm busy. I have to work. I'm in college. My son's in school too. So like I'm strictly business throughout the school year. So I don't have time to travel with him or do major fun things or travel out of town with him. I think he should be held accountable because he doesn't have.
That's my question.
I didn't get to finish though.
Hang on a second. Whenever you propose a problem, you have to propose a consequence. So what is the consequence you're asking me to do for him not abiding by the in-school parenting time? That's what I want.
What is the consequence when you don't follow a parenting order?
Are you asking me questions now?
I'm asking you, yes.
No. You don't get to ask me questions. I get to ask you questions, so that's kind of unfair, but.
Well, I'm not here to take away any of his parenting time. I just feel like he should be held accountable. I'm not here to take away any of his parenting time. So whatever happens when you file a complaint and the other parent doesn't follow the parenting order, that should be the consequence.
Okay.
It's not for me to.
Did you say it's not for you to decide?
That's not for me to decide his parenting time. I feel like he should follow it, of course, but that's not for me to take away any time with his child.
Okay. Mr. Schaefer.
I'm hearing contradictory things. Ms. Williams says she doesn't want to take away his parenting
Emotion meets procedure, with personal struggles laid bare.
Time, and yet that's exactly what her motion proposes. Now, we did indicate that she gets 3 weeks with the minor child in the summer, and 2 of those weeks are in August, so they have time for a long, leisurely vacation. It was not clear to Mr. Webley how much of an issue the 1, 2, 3, 4, 5 weekends during the school year were to Ms. Williams. He had been exercising the parenting time every 90 days instead of every 60 days, and will scrupulously adhere to the order going forward and do the weekends every 60 days. There have been issues with Ms. Williams in terms of she has serious anxiety and has.
No, I do not. That's not court. You do not have my medical history to say that.
Stop a second. Ms. Williams, I know you're representing yourself, but you do not or cannot just jump in whenever you feel like it. It's your motion. I will always give you the last word, but you can't interrupt people because not only is it rude, but it mutes out microphones and then I can't hear what's going on.
I'm
So,
sorry, Your Honor.
Mr. Schaefer, sorry about that. Go ahead.
So Ms. Williams has made it challenging to exercise the parenting time, but we're going to persevere here and make it happen this school year, Your Honor. And so that's something Mr. Webley is perfectly capable of and willing to do. This just came up really in the spring. It was sent to mediation with the Dispute Resolution Center. Ms. Williams elected to go with friend of the court, and it wasn't worked out. So now that we're here with the school year, we can scrupulously adhere to the school year parenting time.
I give you the last word, Ms. Williams.
That is not, you don't have no say so of saying anybody has anxiety or anything of that case, honestly. I don't get, we had this since 2022. To only come one time out of all of those years, that makes no sense at all. Like, what makes, now that I file a motion, that you're gonna step up and do what you're supposed to do? That makes no sense to me. And if he followed the school year of coming to see him like he's supposed to, it wouldn't be such an argument of him wanting to hold the summer hostage, because those 3 weeks that he comes back, yes, I have to get him back on track of, hey, back on bedtime, because his bedtime during the summer is 11 o'clock. I have to go to the dentist, his doctors, and get him back trained to get ready to get up at 7 o'clock in the morning and go to bed at like 9. So those 3 weeks are not enough time for me to do what he says that I can do, is travel for a long time out of state. That's not what I do, because guess what? I'm in college too. School starts for me around the same time as our son does in August.
Thank you. Well, I received a motion that, in essence, said that, or asked that parenting time be changed. And courts cannot just change parenting time. There has to be something called a threshold that was set forth in probably the seminal case in parenting
The weight of consequence looms, raising the stakes for both sides.
time of Shade versus Wright, 291 Michigan Appeal 17, a 2010 case. It says I have to have proper cause or change of circumstance, even if it's not as stringent as the custody threshold. What was alleged in the motion was that first, the defendant is inconsistent with school year parenting time. Second, that the child misses out on free opportunities for those types of extracurricular activities. And third is that the child is suffering from emotional stress. There's nothing by way of any type of medical professional that I read anywhere that backs that up. It may be that he is suffering with stress. Let me turn first of all to the school time, parenting time. Courts enforce court orders. And if Mr. Webley is not following the court order, as Ms. Williams suggests, during the school year, then pursuant to statute, MCL 552.644, she should file a complaint with the friend of the court. They will then try and resolve it between the parties. And if they can't, they will bring it in front of me on what's called an order to show cause. And then I'll have to determine the penalty for it. It'll be either a monetary penalty. If it's so egregious, I could quite simply discontinue the school year parenting time. And if it's really egregious, could recommend that Mr. Webley be incarcerated. Those are all things that are available when somebody doesn't follow a parenting time order. And I'm prepared to do any of those things, but those have to be initiated at the front of the court, not with me. So I will leave Ms. Williams to that if that situation arises. But at the end of the day, I do not find any proper cause or change of circumstance to change any parenting time at this stage. And I'm going to respectfully deny the motion. Mr. Schaefer, will you prepare that order, please?
Yes, I will, Your Honor.
All right. Thank you both, or all of you, very much. And I wish the best for all of you and your son. What can I do for you, Ms. Williams?
If I disagree, because I went to legal assistance, they tell me if I disagree with you, that what do I do after this? Because I 100% disagree. Just come back up there and file another.
You can 150% disagree with me. You always have the right, and wait till you get Mr. Schaefer's order. It'll say it right on the bottom of what you need to do and the time frame you need to do it at. And you can try your motion with Judge Gottlieb. Okay?
Yes. Thank you.
All right. Thank you.
The motion is denied, but appeals remain. Her fight isn't over yet. The ruling lands hard, yet the door to challenge stays open. All right, guys, don't forget to like this video, subscribe to the channel, and we'll see you in the next video.